Hello and welcome back to our video updates. In today's video, I would like to address a couple of questions that we've received about service of process whenever somebody has been sued. So this question implies that the person asking the question is the defendant or the potential defendant, and they're concerned about what to expect if another party or a company, such as a creditor, is trying to sue them. And so I'll cover generally how it works. I'll cover the specific questions that I received, and I'll also talk about how things have slightly changed during the pandemic. So the first question we received was whether the plaintiff could actually serve somebody that's in the hospital or in hospice. And of course, hospice is way more serious than just being in a hospital, depending on what the person is in hospital for. So obviously somebody could be in hospital because they're temporarily ill and they've been admitted and will be released or discharged soon. The hospice, on the other hand, implies that that is a terminal illness, and so the person is likely going to pass away sooner than later. So what exactly are the differences there, and can a plaintiff successfully serve somebody in that kind of a situation? Of course, if you're somebody that works in the hospital, then of course you can be served. If you actually are just somebody that works in the hospital and the plaintiff has put down your work address as a place where you could be served, then it's possible that you could be served at the hospital just for the fact that you do work there. But it has to be personal service, meaning that it has to be handed to you, not to your coworker or anybody else. So that's what we mean by personal service. And then, of course, they could also mail something. Let's say that it was your actual business that you owned, or that you're the president of that business. But of course, if you're working in a hospital, typically you don't own the hospital. So service by certified mail may not be effective in that situation. So to address the original question, if the defendant is actually a patient as opposed to somebody that works in the hospital, then the process server could potentially still go over there and serve that defendant if the family members or whoever is at the house has already told the process server that that's where the defendant currently is. So the process server could go there if he or she is allowed to get in there and actually identifies the person as the proper party to the lawsuit and personally serves that defendant. If somebody is out of it completely and not able to communicate or able to interact with others, then obviously the process server would not be successful at that kind of a service. The related question about hospice is that the people that are in hospice, they're terminally ill. So can a process server potentially serve somebody who's in hospice? Yes, they can, but it's questionable as to whether the person being served is fully cognizant of what's going on. Most seasoned process servers will not serve somebody that's in hospice. If the process server is quite aggressive and feels compelled to do so, there is going to be a potential issue there once the defendant gets served in hospice and the family members hire a lawyer to work on the case. The lawyer could strike that service of process. So what we typically file is a motion to strike the service of citation or process. And then the court would probably side with the defendant in that situation, not because the law says definitively that you cannot serve somebody in hospice, but just because it's common sense that most people that are in hospice are not always responsive. They're not always fully aware. They don't always have all their abilities around them to be able to process what's going on. So that is the type of service that could be questionable or could be attacked in future. The other questions about service is that during the times of the pandemic, what if I don't want to open the door to just anybody because I'm avoiding people? Well, you don't have to open the door to the process server if you don't want to. If you are the defendant, the process server could still identify you, obviously, if you're able to talk to each other, and you could still maintain the distance of 6 feet that's recommended by the CDC. And if you just flat out don't open the door at all, the process server would have to go back and file an affidavit explaining what happened. It has to be very specific as to your rejection of the papers or your refusal to open the door at all. And then they'll file something called a motion for substituted service or a motion for alternative service. Once that's filed, then the motion would request different ways to serve you. So typically they could still go ahead and serve you by attaching the court documents to your front door, the main entrance, or they could serve you via email or by certified mail, or all of those different methods. They could also serve you by delivering the documents to somebody at your house. Now, the other ways that people are serving these days is by social media. So all of those can be requested once the initial personal service has been attempted. And that's how everybody is doing it these days. The Texas rules actually allow plaintiffs to serve defendants via certified mail. So the personal service is not necessary. It's just the most common way that people like to do it to ensure that the documents get into the right hands right away. The certified mail can also be done, and it could be done through the clerk of the court or the constable. And if it's a company that's being sued, now that most companies are not necessarily working from the office building, but instead working remotely, then the service could be done through the Secretary of State, which means that the Secretary of State would send those documents by certified mail and return the service. Every time documents are served on a party, there is a return of service that's filed with the court. And the return just explains that they were successful in serving that other party, or you have an affidavit filed explaining why the service was unsuccessful. And then the plaintiff will still get another chance to figure out other ways to still serve the defendant. Ultimately, the defendant is going to get served regardless. So it's just a matter of delaying the inevitable. And then if the service was not properly done, in your opinion, if you believe that there was any violation there, or if a lawyer has informed you that there's violation there, then of course you would move to strike the service, and then the plaintiff will have to start all over again. So you could make an appearance to move to strike that service without making an actual appearance. So we call it subject to a special appearance, because you're not saying I'm showing up to defend myself or to answer to the lawsuit. You're not acknowledging the lawsuit itself. You're essentially just showing up to attack the method of service of the lawsuit, the papers. And so that's called a special appearance. And those are the questions that people had. It's rather unfortunate that a lot of people are sick this year. I mean, people are sick all the time, but this year especially so, and more serious or more rampant, and just something different that we haven't experienced before. So the process servers, when they're using their judgment, they don't necessarily get that aggressive and show up to a hospital to serve someone. And of course, because of the COVID, they wouldn't even be able to gain access to people to serve them in the first place. But pre-pandemic times, they were able to go to a hospital if they needed to, which I actually just think is not very professional. But if they needed to do it, they were allowed to do that under the law. Most of them would not do that. As I said before, they would rather go back and tell the plaintiff that they were unsuccessful, and then they would request an alternative method of service by serving the relatives, or by serving it in some other way, so that it's calculated to reach the defendant ultimately. So that's my quick overview for today, for educational purposes as always, because people are asking these questions. And I would just say, yes, they could serve you if you're ill, and yes, they could serve your relative if your relative is terminally ill, unfortunately. But there are things you can do to still defend that relative, or to help stop the lawsuit in its tracks. So if somebody is in hospice and you've already attacked the method of service, or maybe they served it properly and there's no attack that you could make on the service itself, you could still have a chance to file a response, a real response, by appearing in the case on behalf of the defendant. Of course, the lawyer would file a response asking for the court to abate the proceedings until the person's health is improved. If that person is just ill, or if somebody's terminally ill, they'll ask for an abatement, just because nothing can be done until the health crisis is sorted out. And later on, when the person passes away, the representative of the estate will step in to take care of that lawsuit. So the things that are a little complicated when health is involved, and then there are lawsuits pending or about to happen, and people can't really have the presence of mind to handle those two things, because health comes first, of course. And it's just difficult when somebody's trying to sue you and you're already in hospital worrying about your health. So there will always be some sort of defense that your lawyer could put forward to put a pause. The abatement is really a pause. You put a pause on the lawsuit, and then it can be resumed later on when the person's better. If the person passes away, then of course the estate will deal with that lawsuit. So that's my overview for you for today. If you have other questions that you are interested in us covering on the channel, make sure to send us an email or drop a note below, and we'll try our best to cover them. And I appreciate you watching as always, and we'll talk to you next time.